Okay, so welcome to Search and Seizure Saturday. We are, I'm planning to keep these going and not have any more hiatuses. Anne is just got back from Oregon. I have not sent her the cases that I'm going to talk about, but she always offers great follow-ups and other questions and so forth. So, yep. So Anna's going to wing it. So just know that Anne has not seen these cases and doesn't even know anything I'm going to talk about. So just kind of make sure you keep that in mind when when I'm asking her for some feedback, it'd be off the cuff. So my name is Anthony Bandiero. And anyway, I have because I didn't know that Anne was going to be here, I usually will show her bio as well. What's up, Selena? Okay, so my name is Anthony Bandiero. I'm an attorney and senior legal instructor with Blue to Gold Law Enforcement Training. I'm also here with my bestie, Ann Kelleher, another cop turned attorney. Okay, cop turned attorney. That is our specialty. We are very, very pro-police in the sense that we love teaching cops. It's in our blood, and we are very passionate about it. So, exactly. Why would you want to? Yeah, Ann, are you looking at getting back into, giving up your law license and getting maybe Portland PD? Work for Portland PD. Actually, I better not say, because Ann probably would consider that. She loves being a law enforcement officer. Yep. For $30K. Is that per week? Okay. Here are the 3 books that we have authored at Blue to Gold Law Enforcement Training. We have other publications. We do a reprint of the FLETC Supreme Court Guide, which I absolutely love. You can't replicate that. The only way to do it right is to reprint and to offer a print version of what they do. But these are Blue to Gold's books. The Search and Seizure Survival Guide is, I think, fantastic to point you in the right direction about what you need to articulate for your search and seizure issues. The report writing book, and finally the brand new book, which has shipped this week to the hundreds of people who have ordered that, is the RS and PC Pocket Guide. This book is designed to give you ideas to help you find those breadcrumbs, those criminal breadcrumbs hidden in plain sight. So, yep. So those books are shipping. At Corona, we tried it. We were hoping to get them out by July 6th or 10th. And there's been just very hard to print as many books as we wanted. But anyway, they are shipping. They are shipping. What's up, Nathan? Okay. So, disclaimers. Laws and agencies may be more, policies, SOPs may be more restrictive, right? We are just sharing with you what we think the national standard is. Second, if you have any doubts about the legality of your actions, push up the chain. And finally, Ann and I are not giving you legal advice. We are not telling you what you should do. We are simply telling you what we think the law is looking for in various search and seizure scenarios, including your questions. It's just our opinion. It's legal education, First Amendment rights, not legal advice. Okay, to get your cert, go to the website. And has anybody seen our new website, by the way? Any feedback on that? We are extremely excited about it. We completely yeah, see Kevin's already getting us in trouble. See that, Ann? So yeah, Dennis says it's way more user-friendly. We love the new website. And it's also, I love the pictures. All the pictures they're just so pro-police, and there's great quotes on there. So anyway, we hope you like it, right? All right. So here's how it works, okay? I have a couple cases for you. These are just cases I've read, and they make some good points, and I want to talk about them. But remember, this is really for you, right? Search and Seizure Saturdays is a time for you to get your questions answered. So if you have a search and seizure question, ask it, and Ann or I will address it. But until if you're thinking of something, let me kind of talk about some cases. All right, that's old. Okay, so let's talk about the latest news, okay? So The first case I want to share with you is out of the Seventh Circuit. It was decided on July 13th, 2020, so just a few days ago. It's Sharon Brown versus Polk County, Wisconsin. Now, this case involves a medical search. And I was like, we don't really talk about a lot of medical searches. And so I figured this would be a good time to kind of talk about the law, some of the considerations and so forth. So I'm gonna look at my other screen. That's why I'm not looking at the camera, but I'm gonna read to you basically the facts of the case, just the highlights. And this is also an example of how the book is used, right? So I talk about medical procedures in the book. And this is the case involving Brown is involving a warrantless search done in a jail setting. But still, some of the things I talk about in the warrantless setting and for warrants as well are going to apply. Dignified manner, private room, medical professionals, taking everything nice and slow. Do not violate the person's dignity and so forth. So, but that's kind of what I talk about. So these principles can be used. Now, here's the fact. So Sharon Brown got arrested for shoplifting in May 2017, right? So pre-Rona, not a cite and release. She's going to jail. Now, while the next day, an inmate came up to the nurse and said that Sharon had approximately an 8-ball of methamphetamine in her private parts. Now, the nurse was not familiar with that particular inmate and wasn't sure if the nurse wasn't sure if she could trust that particular inmate, just maybe try to get Sharon in trouble or whatever. So the nurse went to another well-known and somewhat trusted inmate that the nurse had no reason to believe would be lying, and asked if there was anything going on with Sharon Brown. What did that inmate say? She's hiding methamphetamine in her private parts. And the inmate gave very detailed description of what the bag looked like. She also described Sharon going to the bathroom multiple times in a very shady kind of way, just to try to readjust the narcotics and so forth. So now the nurse is like, all right, now there's two inmates. They're not connected. Like, they didn't both come up to the nurse at the same time. This other inmate also knew about the narcotics. And the nurse was also told that Sharon mentioned to the inmates that she needed help hiding it because it wasn't packaged properly, which implies that if she kept it secreted, in her private area, that it could, rupture and cause an overdose and so forth. So that's why she was also seeking out other people's help to conceal the contraband. All right. So the Polk County Jail has a policy addressing this issue. And it says, this is what it says. It says that if reasonable grounds to believe that the person is concealing weapons, contraband, or evidence in a body cavity, or otherwise believes that the safety and security of the jail would benefit from a cavity search, then it may be done, but can only be performed by a medical personnel licensed in the state of Wisconsin. Okay, so that's their policy. Now, this is warrantless. The policy does not say that you have to go get a warrant from a judge. So the nurse, the officer, and another officer all went to the chief deputy of the jail, okay? And they asked for his permission to bring Sharon down to the hospital to do a cavity search without a warrant. And the chief deputy signed off on it. So they bring her to the hospital. They bring her into a private room. And the first thing that the doctor does is an ultrasound on her abdomen area. And the ultrasound did not detect any contraband. But I mean, you can kind of see that, I'm not a medical professional by any means, but just from what I know about ultrasounds, it's, if you're looking for something 3.5 grams approximately of methamphetamine, I'm not positive that the ultrasound is conclusive. It seems to me that it could be missed, So the doctor does the ultrasound. It's inconclusive, doesn't find anything on there, and then does a cavity search. So I'm going to read you some of the language from the case. And the reason I'm doing this, not to, I'm reading to you because it just reminds us how intrusive this search is. Okay. This is the big leagues. Okay. When it comes to search and seizure, this is the big leagues. And here's what the court said. The ultrasound revealed no contraband. The doctor then conducted a vaginal exam by inserting a speculum to spread and hold open the vaginal walls to see inside. This exam was brief and similar to a routine pelvic exam or a pap smear. The rectal exam began in much the same manner. The doctor used a speculum to widen the anus and peer inside. And it also talks about how the doctor's headlight, his headlamp died with batteries. He had to go looking around the hospital for some batteries, and why the speculum is in the inmate's anus. And she's also suing about that. She says the whole thing was just completely unreasonable, right? All right. Okay. All right. Okay, Jason brings up another good point too. I personally, probably, if I was a doctor, I wouldn't be doing this either without a warrant, but they did it in Wisconsin. Okay, so no drugs were found. Okay, so what does she do? She gets released and she goes to get a lawyer, and she sues the Polk County Jail, right, including the deputy chief, the nurse, and everybody. Let me ask you, okay, just to get one thing out of the way. Is this even a Fourth Amendment search? Remember, it's not the officers that did this. It's the doctor. So is this a Fourth Amendment search, yes or no? I see a lot of no's, okay? I see a lot of no's. So if you've been to the advanced search and seizure training class, right? That's right, Sean. Sean has been to my class, right? And what is the first question, right? What is the first question that we ask when we're dealing with a search and seizure issue? The first question is, was it a government actor or their agent? And right? And when you have, are they the agent? Did the police encourage, participate, or direct that the search occur? Correct. So, right. It's not like, now there may be some examples of, look, if the cops bring a drunk, a drunk person to the hospital to clear them, and all the cops are saying is, hey, we are just looking to clear this guy, for medically clear him, right? And then the doctor pumps the guy's stomach. Is that a Fourth Amendment search? Yes or no? Correct. Right. Correct. There is no direction, participation, or encouraging the stomach pumping. But that's not the case here. She was brought to the hospital to conduct this search, right? They want a cavity search done. So this is a Fourth Amendment search. Okay. All right. So was the medical procedure reasonable under the Fourth Amendment? Now, what is your reaction to it? Okay. Think legally here. Okay. The emotions do have to come out of it. Was this reasonable under the Fourth Amendment? Yes or no? Dennis is like, hell no. Okay. Anne, you have not read this case, I assume, right? Do you know anything about this case, Anne? Okay. What is given you the facts, you are a search and seizure expert. What is your reaction? Do you think reasonable or unreasonable? What's your reaction? What do you think? If you had to call it with the limited facts I just gave you. Limited facts. What do you think? Rich says reasonable. Anne is correct. So look, it was upheld as reasonable, and Anne hit it on the head because of the environment. She is right, but do whoa, Kevin, do not leave this webinar and think that this is what I would have done, right? Don't think I would have done this, okay? I'm just saying we got to look at the law. So the law is in the favor of the corrections officers, okay? Yeah, right. Okay, so the first principle, okay? The first principle is that in the quote, these are quotes, right? Incarceration curbs constitutional protections, but it does not extinguish them. So just like Ann said, right? Jails are different. You're going to get more leeway in a jail. Okay. That's just the way it is. So if this was a out of custody suspect, I think you're done. I think you're absolutely done personally. Right. But you are in a jail. So you're going to get a little extra. The U.S. Supreme Court upheld the constitutionality of a jail policy requiring that all inmates to undergo a strip search, including a visual examination of their body cavities every time they return from a contact visit. I'm just kind of giving you an idea. Now, this is the Supreme Court case we have on a similar issue, but this Supreme Court case did not uphold the intrusion, right? The actual physical entering of a body cavity. That's not what this case is. It's just saying the Supreme Court has upheld suspicionless visual strip searches. However, this is not suspicionless. This is based off of reasonable suspicion, right? That Sharon has something. So Brown was not searched as part of a practice that applied to everyone housed in the Polk County Jail. She alone was selected for a search, and a quite invasive one at that. In these circumstances, the search must be supported by reasonable suspicion, at least, or probable cause. So we strain to conceive of a search more invasive than the one performed on Brown. I think actually somebody said that, right? Somebody says, Kevin says, you can't get more intrusive into someone's body, right? And that's what the court is saying here. Even a visual scan of a bare body is an extraordinarily interference with privacy. In Brown's case, it was not only someone visually inspecting her naked body and closely examining the most private parts but someone who did so by making physical contact, prying open her vaginal and anus. That's from the court. That's not for me, right? That's pretty, man. I mean, that's serious. But here's why the court upheld it. Okay. We see what Ronald. So, was the jail's medical staff purpose to charge her criminally or to keep her from OD by leakage or distribution for other inmates, creating a dangerous situation? I believe that the main motive here was not really the criminal motivation. It was the safety of the jail and the safety of her. Does that make sense? The jail is responsible for the inmate's health and safety. So for liability reasons, if they didn't get the dope after the fact's given and she dies, then the family sues the department. Correct. So if they go to court, if the cops go to court and they say, or the COs, right, and they say, they're asked, what was your motive, right? Why did you do this? And they say, we want to recover evidence. I think that's bad, right? That's the only reason, right? But there's something more going on here. It's her health and the welfare of the jail. Okay. 2 inmates corroborated the reasonable suspicion with many details, right? It wasn't just some like, hey, we think she has dope because she's acting sketchy. The nurse believed them. Now, the nurse, again, that's another important factor. She is involved in this, right? It's not just the cops, it's the nurse. The nurse is going to have some extra credibility in this case. It's a jail setting, key, right? It's not out in the field. Obligation to protect Brown from harm, right? Because she could overdose and die. They're in charge of her, right? They have an obligation to keep her safe. There's a written policy in place. So it's not like these cops are just making up their own rules. And it was approved by the chief. Did they charge her? No, there's nothing to charge her with, right? There's nothing to charge her with. There's no evidence. So there's no crime, essentially. I like that crew. Kevin, if they didn't consult with the nurse, maybe it would have been different view. Nurse, health concern. Look, these are totality of the circumstances, but the nurse is certainly going to help. Now, so remember, so the intrusion, right? The constitutional intrusion has to be reasonable at its inception, okay? And it has to be reasonable when it's carried out, the search or the seizure. So right from the minute go, we are going to bring her to the hospital and have this doctor do this. It also has to be done in a reasonable manner. Remember, the doctor is an agent of police. So we are going to also have, we're going to have to make sure that he is also being reasonable under the Fourth Amendment. So we have to have considerations, right? So why is he being reasonable? Number one, conducted in a medical setting. Well, the policy said that. It has to be a Wisconsin doctor. Private room. It might seem obvious to you that we're not going to do this in a open setting, but there are cases where the public could see the inmates being worked on and so forth, and inspected, and we don't want any non-essential people to be looking at this. Okay? Conducted by medical personnel. Cops left the room. There was no safety issue. She was actually, it appears from the case that Sharon was being cooperative in a sense. I mean, I don't think she was happy with this is going on, but she was being cooperative. Overall, time was brief, right? It wasn't like this inspection took 2 hours. It's not clear how long it took, but the court did say it was as brief as reasonable, and no force was used. In fact, I think if she resisted and they had to hold her down and force her to go through this procedure, I think that it changes the outcome, because force is going to be one of those things that the courts consider. Right? Exactly. It could be rape. I mean, you have to have the intent for rape, but I think that's when you go get a warrant, unless you have hard evidence that she is in jeopardy of imminent death, right? Anne, do you want to throw? I think that's the end of my. So here's my takeaway. Anne, I want to see if you want to have anything to add to this case. But my takeaway is push decision up the chain, be reasonable, write a solid report. I personally, I wish, if you think you have probable cause and if there's no imminent, but I'm not even sure if anybody even on here is a CO, right? But whether you're a CO or not, or, you become in charge of a jail, you get elected sheriff or whatever, you're a chief and you have a jail, right? I actually think, and they didn't decide this, but I think they have probable cause for a warrant. That's what I think. I think those two witnesses and everything going on, they have probable cause. Anne, do you have anything? You want to add anything?
Can you hear me?
Yeah.
Okay. Yeah, I think when we look at what is the privacy interest at stake, what is the compelling government interest, obviously where the privacy interest here is probably as high as one can get with the invasiveness, the way in which the staff went through carefully and cautiously confirming and corroborating the information, walking it up the chain, considering what is going to be the least restrictive thing we can do. And then that's exactly what medical did, right? They did the least restrictive things first and worked their way up in invasive procedures in an effort to find whatever they thought might have been stashed up there. I think the only other thing that they might have been able to do is do a cell search first to see if they could recover any dope in the cell before, as far as walking up the chain of least invasive. But I think all of that, all together, the totality of all of those circumstances is really what the court was looking for, and where that focus was the safety of the jail. So, yeah.
And when I talk about these medical issues in my classes, one thing that I try to reiterate to the officers, and by the way, these are really, it doesn't come up too often, the jail, because we don't teach a lot of COs. I mean, even though we have a lot of COs in our classes, but I'm talking mostly with the strip searches that happen usually at jails, or I'm sorry, at the police department. They'll transport somebody back and they have probable cause to believe somebody has contraband on them. What I teach is when they write their report to really, talk about the dignity and the privacy, and just the fact that you really, you're everything was sterile, and it was just, I think the courts want to see that. Would you agree with that or no?
Absolutely, because it does demonstrate not only that, we are not just goal oriented. It's not just about getting in there and getting the dope. It is doing that as safely and as compassionately and as considerately as possible for the safety purpose. Yeah, for that safety reason.
Right, exactly. Okay. All right, guys, that's one case, right? Let's talk about another case. So here is Raymond Marling versus Frank Littlejohn, right? Littlejohn is a deputy warden. So this is what this is about, and why Raymond is our inmate. Okay, it's another he's an inmate, but this is actually going to concern the inventory exception to the motor vehicle, to searching inventorying vehicles. So Frank is getting sued by Raymond under a writ of habeas corpus. So basically, the constitutional principle that somebody locked up can try to free themselves by pointing to a constitutional violation that caused them to be in prison, right? So that's why this case is structured like Raymond versus the deputy warden. So this is another Seventh Circuit case, but I like it because it actually brings up a topic that doesn't come up too often, but involves inventory searches and breaking open a closed container. So again, this is an example of how the book is used. I do talk about, inventory searches here. We talk about inventory searches during our advanced traffic stops class. And, you have to have a written policy that minimizes discretion. We don't want these to be, a subterfuge for a cop just towing a car when they really just want to just search for evidence, and that's their main motive. We want to prevent that and really kind of reduce those. I call them short circuits of the Fourth Amendment. The policy describes what may be searched and inventory. That's what's going to come up in this case. And you articulate some legitimate community caretaking rationale. All right. So there's that. So here's the facts. So kind of a straightforward case. What happened here is Raymond Marling was, the cops, they're looking for somebody else. Okay. So they're looking for a fugitive, but they know that the fugitive hangs out with Marling. So they run Marling. Marling has an arrest warrant for some misdemeanor, right? So they see him driving down. They see the car driving down the street, and they're not positive that he's in it, but it's registered to his wife. So they stop the car. Marling is in it. He's a sole occupant and driver. They arrest him for the warrant, and then they start doing an inventory search because the car there was no shoulder where they pulled him over. So they're going to have to tow it because it's blocking traffic. So they start inventorying the car, and they found a gun underneath the seat. Well, Raymond is a felon, so that's a problem for him. And then, still working on their inventory, okay, they saw a locked box in the trunk. And the officer took a screwdriver and pried open the locked box and found methamphetamine. Now, this is one of those things where it's just kind of crazy to me, but the methamphetamine is approximately it's less than a gram. Okay, it's less than a gram. But because of Marling's record, those drugs play a part in his sentencing, and they give him 38 years in an Indiana prison. So, okay. So again, let's look at the law, right? I mean, man, for less than a gram, though, I mean, that how much does that cost the taxpayers, right? Right, exactly. Joseph is citing and releasing that guy. Joseph, you'd be lucky. Are you California? Right? You'd be lucky, right? In some states, if he got 38 days in jail for that, right? Can you imagine, sir? You know what I mean? Yeah. Oh, that's right. Michael from Oregon is here. I don't know if you I don't know if you were you in that Eugene class, Michael, with Ann? Not sure. Oh, too bad. That was too bad. Next time. All right. Okay. And in Chicago, Jason, do you give him back the gun in Chicago so that you can get him again? Is that what you meant by catch and release? All right. So, all right. So here's the question. Did breaking open the locked box, right, violate the Fourth Amendment? All right. So here is the policy. This is what the policy told the cop to break into. Closed and or locked containers. Inventory all closed or locked containers. If a situation exists that requires extreme measures and or unreasonable potential damage to property, the officer should avoid opening the container, but should document why the container was not opened. They opened it after the gun was found. Where are you going with that, Dennis? So, Sean, resend it out to all attendees. That's a good point. Okay. Okay. So that's what the policy says. Now, the court acknowledged that the officer did do some damage to the lock container, right? When he actually opened it with a screwdriver. Okay. All right. So here we go with some language, okay? Our view that standardized criteria or established routine must regulate the opening of containers found during inventory searches is based on the principle that an inventory search must not be a ruse for a general rummaging in order to discover incriminating evidence. So generally speaking, we do not want to go like this with our partner. Hey, I want to get into that car. And your partner's like, all right, yeah, me too. I mean, there's probably something in there. How do we get in it? We don't have probable cause. Yeah, we don't have probable cause. You know what? That registration's expired, or he has no insurance. Let's tow it, and that'll get us into it. And the cop and his friend goes, well, do we have any other? Will we normally tow for this? No, we wouldn't normally tow for it, but let's get into that car. The courts do not want that. Okay, even though it happens all the time. Okay, but what we teach is don't do it, right? The courts are they know that cops have done stuff like that. I've done it like that because, you know, when I worked, I wasn't really taught that inventories couldn't really be a ruse. I just had to have a reason to tow. But looking back at it, we want a community caretaking, right? We want community caretaking. So Mark says, I'm still concerned about the stop. The vehicle was in the wife's name and they didn't know who was driving. Would this be enough PC for stop? Well, we don't have PC. We have, I think, reasonable suspicion. Right, especially if there's a male driver. Now, I think that the stop occurred at night, and it does not say. By the way, the defense attorney is not going after the stop itself, and we do have Kansas versus Glover, which reaffirms that we can make a reasonable inference, right? And is it a reasonable inference that a husband could also be driving the family car? In fact, I think it is. I mean, my cars are in my name, but my wife drives them, right? So, right. Right. But if they did see that a female is driving, then it's, or if they saw a female's driving and there was no passenger, then I think we're off limits, like a male passenger. Okay. So that's where we are. So don't use inventory searches as a short circuit to the Fourth Amendment. Don't do it. You're making bad case law. And in California, for example, they've already addressed that issue head on last year. So in California, you have to have a legitimate community caretaking. You have to have blocked traffic, risk of vandalism, illegally parked. If you do not have one of those, you can't even inventory the car. The car has to stay, unless the person, right? And by the way, Dennis, Cali's tough on it, but actually, I believe Cali is ahead of the curve on this issue. And I believe that I think all states are eventually going to get to where Cali is, because they just don't want any more ruses, right? And is confirming that it's definitely the trend. Iowa is now in that line, and some other cases, New Mexico and so forth. But I believe it's actually good case law. Okay, so the policy or practice governing inventory searches should be designed to produce an inventory, right? The individual police officer must not be allowed so much latitude that inventory searches are turned into a purposeful and general means of discovering evidence of a crime. But in forbidding discretion to police officers conducting inventory searches, there is no reason to insist that they be conducted in a totally mechanical, all or nothing fashion. This is good stuff, okay? So the policy, per the Supreme Court, okay, the policy is supposed to reduce or eliminate discretion, but it does not say you cannot have any discretion. That's not what it says, okay? A police officer may be allowed sufficient latitude to determine whether a particular container should or should not be opened in light of the nature of the search and the characteristics of the container itself, right? Then not a lot of damage will be done, or the officer really thinks that something is valuable in this bag and they want to inventory it. I mean, the policy has to kind of give you some direction, but there is some decision-making that occurs on the field, in the field. The policy is valid under Wells. Wells is a U.S. Supreme Court case that says that as long as you have a policy and so forth, you're good to go, and even with some discretion. And you can open up closed containers. That's what really Wells is about, is opening closed containers or locked containers during a search. It combines a presumptive rule of opening everything with a discretionary should exception when the damage would be unreasonable, right, in the officer's judgment. So you can open it, but if you're going to break, if it's going to be unreasonable, then don't do it. And because the policy is valid, the search is valid too. A federal judge's, now this is the lower court, agreed with Marling and throughout the enhancement. But because of he thought that this was unreasonable in the Fourth Amendment. But here's what the Seventh Circuit said. A federal judge's disagreement with how an officer exercises discretion under a local policy does not make a search unconstitutional in retrospect. Here's one of the points from the case. When you are looking at the reasonableness of a search or seizure under the Fourth Amendment, we look to constitutional doctrines. A policy, a state law is not going to define what is reasonable under the Fourth Amendment in the vast majority of cases, okay? Because it can't control the Fourth Amendment. The Fourth Amendment controls it. Does that make sense? It's a one-way street. The Fourth Amendment controls your policies. It controls your state law. The state law and policies don't control the Fourth Amendment. So just because, right? Just because the judge here said, you know what? I think that if I was a cop on scene, I would think it's unreasonable the execution of the inventory search. No, it's not what you think. It's not what, even what the policy, even if the policy's, violated, it's what is reasonable under the Fourth Amendment. So the outcome is 38-year sentence upheld, and any other takeaways from this case. And while Ann responds to yes or no, I have no more cases for you. So I want to know if you guys have any questions about things that you guys are working on. So now, personally, okay, and maybe Ann, when it comes to, I personally do not recommend to my clients, at least, that I would have a policy breaking open containers, right? I generally don't do that unless you can get with a key, but if you have to force open a container, and by the way, this one's written pretty well, unreasonable damage, but you got to be careful here. The discretion is the better part of valor. Yeah. So yeah, exactly. They got the gun. Oh, okay. Back up. So they got the gun, but what if the gun was in the box, right? What if it was the other way around? What if they found the 0.36 grams, whatever it was, in the glove compartment, and then they searched the lock case? But now, well, right? Is it the same? I mean, you said we got the gun, but we don't also want to validate our searches by what we find, right? We want to make sure that we are good in the beginning. And let me ask you, based off of the limited, you have not read this case, but do you think that the officer actually has probable cause in this case, potentially, under the motor vehicle exception? And you can use your mic or you can type, but.
The question, felon, prohibited person, gun, is it reasonable to believe that you're going to find other evidence of weapons in the car? I mean, because really, if you find the gun, that's now your probable cause, right? Weapons, ammunition, things like that. There's probably a pretty good case for that, for now a mobile motor vehicle exception to apply. And that's one of the things that we really, really talked about in Oregon, where Oregon has a really, really high preference for warrants. Once your inventory search discovers evidence of a crime, are you still conducting an inventory at this point, or have you swapped over to the probable cause search and kind of talking about how to deal with that question? So yeah, but I think here, I mean, again, what is reasonable damage is definitely going to be a matter of officer discretion, and one that would have to be well articulated, either whether you decide not to open the box or the opening that box. What part of that unreasonable damage? How do we define that as officers? That's kind of a tricky question. So, but yeah, those are things that I would definitely think about under similar circumstances for you guys.
Yeah, the case did not discuss at all the motor vehicle exception, which does surprise me personally. My inkling based off of what I know, Carol, I would have went down the motor vehicle search avenue first, and then would have used the more difficult, is this unreasonable damage to the guy's property? I think, I guess my question for you is, do you think with the facts that I gave you before opening that case or the lock container, do you think a judge would give you a warrant to search the open container? The closed container. And if you think the answer is yes, well, tell me why, right? And tell me why, because there could be ammo in there. If there's other indicia of drug use or sales, of course, maybe that's where he puts his stash. I'm not going to say it's a given. You got to tell me what you would tell the judge, because that's how you look at it, right? That's what the motor vehicle exception is. The motor vehicle exception is you get to search the car in the same manner as if you had a warrant, but you still have to be able to get that warrant. Otherwise, you have no Carroll doctrine in play. So I think the answer is yes. I think I could do it. I think I can go to the judge and deliver probable cause, open that container. But you know, they went down the inventory route. Agree, Carol. But if agent prefers, get a warrant. I think we all, in 2020. I mean, Carol's 1925. Courts, we don't want to abuse our beloved exceptions. There is a war out there, right? There's no relation to that. We mean there's no relation to that doctrine. Kevin, clarify. Okay. If you want to put your mic on, I can also. Sometimes it's hard to really get your point across. You're like, Kevin, I'm good. Okay, he's a felon. He's in possession of a gun in Cali. I don't get the warrant for a box. If it's a safe, yes, I get the warrant. Why necessarily? I mean, a safe, yes, like a gun safe, yes, but no locked box. That's kind of indescript. Right, Dennis? I meant, why would you get the warrant for? Why do you think you can get the warrant for the safe? But that's not this box. I actually think it's a locked box. It has a key or some kind of combination, right? But they broke it. No, he broke it open with a screwdriver. It is something that is. I tried to find a picture of this box because there is a picture. The court talked about a picture of the damage. And I'm so surprised. I looked at all of the filings in the case, and they did not insert the picture in the filings. But I would like to. Me too. I want to see that box too. I tried to find a picture of it, and I couldn't. Right. I think Jason. I'm actually with Jason. I think that I think a judge will, if you can articulate it, and I think I can, will give you a warrant for that locked box, even though it's not a gun safe. It does not say Century gun safe on it or something like that. Right. That's right. That's right. So Dennis is correct. If we are looking at also, the court is not saying here, right, in this Seventh Circuit case, they're not saying that you can do any damage you want, right? And it's as long as the officer thinks it's reasonable. No, it's always going to be in retrospect to some degree. But in this case, it was a close call. Right. Right. No 100% rule. That's correct. All right. So that's the two cases I had for you. I hope that you found them interesting. They're kind of a little off the beaten track of what we normally talk about here. And, this is, I think, part of our discussion is talking about these. Oh, Jason brings up another good point. Finish the inventory. There are cases out there, right, that have found that the officers not finishing the inventory was another indicator that they were up to something, right, Jason? That this was a ruse, that they really did not care, did not care. Here's what you can do, okay, Dennis. Actually, here's what you can do. I believe, okay, that if you are going to transition to a probable cause search, that you don't necessarily finish the inventory. But I think what I'm trying to say here is you should still fill the form out. You should still put a line in there at 12:52 p.m. I found probable cause of other evidence, and I transitioned to a PC search. You still have to have a form, but I still do not want cops. I don't know. I mean, what I'm trying to say is, if you want to transition to an evidence search, you can do it, but you're going to have to still end off that inventory and be clear when it transitions. I want to hear Ann's opinion about that. Ann, what should we do here? Okay. The cop finds the gun, and the cop wants to start looking, and he's going to be honest with the court. He's going to be, Your Honor, I was definitely looking for more ammunition, evidence, and so forth. What should the cop do with that inventory? You heard what I said. I say at that point, you end it off and you transition to a PC search. That's my advice, but I want to hear what you have to say. You may not agree with that.
I actually do, because if our inventories the primary purpose of the inventory is to look for valuables. You're protecting the property owner, you're protecting the the jurisdiction from liability, and you're protecting the community from things that could be likely harmful. So now you're on the stand and the defense attorney's asking you, so what was the purpose of your inventory search? And you list those reasons. Like, so after you found a gun in the car, you did not at that point believe you were also going to find evidence of a crime, right? And it really makes that suppression hearing testimony incredibly difficult. So and so at that point you can say, well, no, at that point I either I concluded the inventory search and either seized the vehicle and got a warrant for it, or transition to a probable cause search under the mobile vehicle exception. So, but while I was doing the probable cause search, I also continued to look for things valuable and completed my inventory. So we got to have a way to be able to distinguish that, especially in our suppression hearing. Otherwise, it completely muddies that inventory search and what you're doing that for, and makes that testimony. And I speak to this not only from firsthand knowledge as an officer in a suppression hearing with that line of questioning, but also as a prosecutor trying to deal with that with my officers and prep them for defense attorneys that I know are going to come after inventories. So in order to protect the sacredity of the inventory.
That's correct. And so the cases, and you know, I just want to make sure we're talking about the same thing, because the cases that I read where the cop did not finish the inventory, what we are talking about is no forms. There is no inventory. In other words, and I think that's what Mark is saying, what Jason is saying, you got to show that the beginning of the inventory was legit. You started your sheet. You should still have an inventory sheet fully completed. Okay. But it's going to say, you know, let's say that you start the inventory at 1 p.m. You find a watch, you find a laptop, then you find a gun. The guy's a felon. Or you find drugs, right? On that inventory sheet is going to probably say something about the gun, the drugs, et cetera. And then, you know, you are going to have to, if your intent is to transition to a rummaging for evidence, you've got to be honest with the court and call it what it is. You're no longer really doing an inventory search. You are, in a sense, you're kind of half and half, but you have to separate those things. And all we're saying is this: if at 1:03 p.m. you found the drugs, and at that point you're like, okay, I think we're going to find more drugs. There's a scale in here. There's tear-offs. And you go up on the stand, and I'm a defense attorney. I ask you, what was your intent at this point? And you're like, yeah, well, part of it's to find evidence. But did you articulate a probable cause? You know, did you find this under inventory? You find this under the motor vehicle exception, and you say inventory. That is, I think, your legal flaw. Why? Because of this. This is based off Supreme Court, right? You know, the Seventh Circuit, but they're basing off of Supreme Court doctrine. They're saying that during inventory searches is based on the principle that an inventory search must not be a ruse for a general rummaging in order to discover incriminating evidence. So your intent is what Ann said: protect the community from dangerous items, protect your agency against false claims, and protect that driver, occupant, whatever, from his property beginning stolen by the tow guy. So that's all. I mean, you're kind of walking a fine line, but I think that legally it's a better position to tell the court what's going on under Carroll versus under Wells. Another future discussion should be the difference between storage and between the storage and impoundments when towing a vehicle. Many people are not keen on distinctions between the two. I can see that, right? But usually when you store a vehicle, aren't you also impounding it though? Usually, aren't you doing some kind of inventory search for the vast majority of cases? I mean, I know maybe I'm missing something there. I don't know. Anyway. So, all right. Anything else? All right, guys. If that's all you have, that's all I have. Can I ask you, was this worth your time? Are you guys glad you came today? Okay. Good. It moves the ball forward, right? It moves the ball forward. That's all we're trying to do here is keep these things relevant in your mind and just talk about these issues. And Dennis is always out there connecting the dots, Ann. All right. All right. So yes, Ronald, we do have on our list of future courses a search warrant class. So we do talk about them a little bit, not a decent amount in our advanced criminal investigations class, but we are going to put together a full discussion of search warrants. But one thing though is search warrants can be statute, there's a lot of statutes involved there. So we got to be careful that, what we're teaching would be valid in the states. It's not just constitutional principles. There's also statutory issues. So we may have to make a state specific class for California, Oregon, and so forth. So that kind of holds us back a little bit. Oh, I see. Sean is now clear. Yes. Oh, I see. Yeah. The DUI interlock. Right. That's right. Maybe in some states, it's like a speed contest, right? If you have a speed contest, your car is seized for 30 days, something like that. But generally speaking, those are still, I'm not sure how that DUI interlock one works. If you're actually, what you're doing about, I don't know. I think still that you're going to do an inventory search for the most part. Jason, aren't you you're my Chicago area cop, right? Dude. Yeah, you are, dude. Thank you. Right. Thank you to everybody, but man, Jason, right. Is no joke where you're at, man. Be safe, brother. All right, guys. Thank you. I will see you. You're welcome, Dennis. Yeah. So the books are all on Kindle. In fact, I'm not sure if the new one is on Kindle yet. I got to look. Wow. It's crazy. Okay. Dennis, I'll add it. Okay. Oh, yeah. I'll add it. You're welcome, brother. All right, guys. Ann, thank you for joining me. And thanks, John. Everybody stay safe. Keep your head up. It's going to get better. This is still the world's best profession. Okay? Law enforcement is still the best profession. Please don't get demoralized. What's going on out there? It's hard not to, but keep your chin up. Okay? We will get through this. And it's gonna be good again. Okay? Don't forget the silent majority. We'll see. We'll see what happens. I think you're gonna be pleasantly surprised. It is worth fighting for, right? I want my kids to be raised in a free country, right? That's right, Dennis. All right, Kevin. Thank you. Frank, thank you, my friend. And we'll see you guys next week.
When it comes to legal training, we're the gold standard. Visit bluetogold.com or call 888-579-7796 today to purchase the Search and Seizure Survival Guide, register for a class, or learn how to bring our search and seizure training to your agency.